Usually when we talk about a new invention or a groundbreaking piece of software, there's this massive, almost underlying expectation of formal validation.
Right, like getting a gold star from the government.
Exactly. You build something amazing in your garage, or you spend, 2 years coding in your basement, and the immediate instinctual thought is just, I need to patent this.
Oh, yeah, or I need to copyright this immediately.
Right, because it feels safe. I mean, it feels like you're taking your fragile new idea and locking it inside this impenetrable, federally backed vault.
It feels official. We have this deep-seated, almost cultural belief that a certificate with a federal seal on it is the ultimate shield against the world.
Yeah, totally.
And it's basically the entrepreneur's version of planting a flag on the moon. You think, well, I have the document, therefore I own the market.
But then you step into the actual chaotic reality of intellectual property law, and suddenly that impenetrable vault starts looking incredibly porous.
Very porous.
In fact, sometimes you realize you didn't build a vault at all, you built a display case.
That is a great way to put it.
We're looking at a strategic landscape today that is, honestly, completely counterintuitive to everything we've been taught in business school or, by watching pitch shows on TV.
It is the absolute definition of a strategic paradox. Because what feels like protection is very often exposure.
Right.
When you choose the route of formal government registration, you are engaging in a very specific, very dangerous transaction.
Okay, let's unpack this. Welcome to the Deep Dive. Today we are talking directly to you. You're the kind of person who is always learning, always building, and always looking for that shortcut to being thoroughly well-informed.
Without drowning in thousands of pages of legal jargon, ideally.
Exactly. We've got a fascinating stack of sources today, primarily drawn from the STARS and SAND IP reference guides, which are these incredibly dense strategic manuals.
They're used by top-tier intellectual property professionals.
Yeah, and we are covering the whole spectrum of protection here. Copyrights, design patents, utility patents, trademarks, and trade secrets.
And our mission today is to navigate this maze and uncover a really surprising truth about how all of these interact.
Right. We're going to explore why the conventional wisdom of, just patent it or just copyright it might actually be the absolute worst move you could make for your business.
We are going to explore why keeping your innovation a fiercely guarded trade secret is often vastly superior to the arduous, incredibly expensive path of begging the government for a temporary monopoly.
Temporary being the operative word there.
Yes. We'll look at the hidden costs of patents, the legal risks of public disclosure, and how the legal framework actually operates when competitors decide they want a piece of your pie.
Because to really grasp the sheer power of a trade secret, I think we first need to understand exactly what you are giving up when you choose the path of formal registration.
You really have to tear down the mythology of the patent and the copyright first.
Let's start with copyrights. The STARS and SAND guide breaks this down brilliantly. Now, as I understand it, copyright protection is essentially automatic, right?
Yes, that's correct.
So the moment I write a line of code or type out a chapter of a book or sketch a character on a napkin, it's mine. I don't have to fill out a form for the right to exist.
The legal phrasing is that protection exists automatically from the moment of creation in a fixed, tangible medium.
A fixed, tangible medium.
Exactly. So the moment the ink dries on the napkin or the moment the digital file is saved to your hard drive, you own the copyright to that expression.
Okay. No filing is required to simply possess a copyright.
None at all.
So if it's automatic, why do people bother formally registering it with the U.S. Copyright Office?
Yeah.
Why pay the fee and fill out the paperwork if I already own it?
Well, because having a right in theory and effectively enforcing that right in a federal courtroom are two wildly different things.
Ah, okay. That makes sense.
The source material lays out the litigation advantages of federal registration very clearly, and it all comes down to leverage and mathematics.
Leverage and mathematics. Okay, explain that.
If you do not have a federal registration before an infringement occurs and someone steals your work, you can only sue them for actual damages.
Let's play that out in a real-world scenario. Let's say I'm an independent software developer. I write a really clever piece of back-end code that sorts data 20% faster.
Okay, good scenario.
I don't register it. A massive tech conglomerate somehow gets a hold of my code, rips it off, and bakes it into their enterprise software.
Right?
I sue them for actual damages. What does that actually mean for me?
It means you have an impossible mountain to climb. Actual damages require you to prove, with forensic accounting, exactly how much money you lost.
Wow.
or exactly how much profit the conglomerate made specifically because of your specific lines of code.
That seems, how do you prove that their enterprise software sales increased because of my sorting algorithm rather than, say, their massive marketing budget?
You can't. Or at least it's incredibly difficult. That sounds like an accounting nightmare, right?
Yeah, I'd be spending hundreds of thousands of dollars on expert witnesses just to prove I lost $10,000.
And that is exactly what the infringers are counting on. They know you can't afford to prove actual damages.
That is so frustrating.
But with federal registration, you unlock a legal superpower. And that is the ability to elect statutory damages.
And the reference guide has some very specific, very intimidating numbers on this.
It really does.
It says statutory damages range from $750 to $30,000 per work infringed.
Right.
And if you can prove willful infringement, meaning you can show they knew they were stealing it, maybe through internal emails you uncover in discovery, that number can skyrocket.
Up to $150,000 per work.
That is massive. And the kicker is you need absolutely no proof of actual financial loss, right?
Exactly. You just prove they copied it, and the judge can hand you a check for $150,000.
Plus attorney fees.
Yes, which is huge. In the American legal system, usually everyone pays their own lawyers.
Right, the American rule.
But if you have your work registered before the infringement began, or within a 3-month grace period of its first publication, you can often recover your attorney fees from the infringer.
So it's a massive stick to hold over them.
Practically speaking, you must register before you can even file a lawsuit in federal court anyway. You can expedite the registration at the last minute if you're about to sue, but it costs a premium.
And it delays your action.
Exactly. Having that registration certificate in hand makes a pre-litigation demand letter highly credible.
So when a lawyer writes a letter saying cease and desist, or we will sue you for $150,000 in statutory damages plus our legal fees, the other side settles.
They settle almost every time.
That sounds incredibly powerful. That sounds like a no-brainer. But, and this is a massive structural but there is a catch.
There is always a catch.
To get that federal court access, to get those juicy statutory damages and attorney fees, you have to satisfy a deposit requirement.
Yeah.
The Stars and Sand Guide explicitly states that copies of the work must be submitted and become part of the Library of Congress collection.
That is the ultimate trade-off of the copyright system. You want the government's biggest stick to hit your competitors with. You have to give the government your work.
You are literally handing your work over to a public repository.
Yes. It creates a permanent, searchable public record of ownership.
Now, for a novelist publishing a thriller or, a musician releasing a pop song, that's totally fine. You want the world to see the work anyway.
It's essential for licensing, for royalties, for estate planning.
But what if we go back to my scenario? What if this is proprietary, highly sensitive back-end software code?
Right.
Or an internal corporate training manual detailing my company's secret sales tactics. To get the strong protection, I have to mail a copy of my secrets to a public building in Washington, D.C.
You do. And while there are some very narrow, complex rules about redacting small portions of trade secret code when depositing software, the fundamental principle remains.
Which is what?
You are placing a version of your intellectual property into the public record. You are giving up secrecy for statutory leverage.
That brings up a massive vulnerability, though, because even if I do hand it over, copyright doesn't protect everything inside that code or that manual, does it?
Not at all. And this is perhaps the most misunderstood concept in creative and technical industries.
Okay, break that down for us.
Copyright only protects expression. It absolutely does not protect ideas, facts, methods of operation, systems, or functional elements.
The guide has a great analogy for this that I want to expand on. It brings up the idea of a detective who solves crimes using deductive logic.
Oh, the Sherlock Holmes example.
Yeah. You cannot copyright the concept of a brilliant, drug-addicted detective living in London. That is an idea.
Exactly.
You can only copyright the specific written expression of that character in a particular novel. Arthur Conan Doyle's exact sentences describing Sherlock Holmes.
Right. So if you write a completely different book about a brilliant, logic-using detective in London named Hemlock Bones, and you use your own words, you haven't violated the copyright.
That's a perfect illustration. Or consider a factual database.
Okay, let's hear it.
Let's say you spend 5 years driving around the country, cataloging the exact GPS coordinates of every single public water fountain in America.
A noble pursuit.
Right. But the facts themselves, the GPS coordinates, are not copyrightable. anyone can use them.
Yes. Only your specific creative selection and arrangement of those facts, maybe the colorful map you drew to display them, might be protected.
But where this really hits the technology sector, and where it becomes a massive crisis for software developers, is with functional elements.
Absolutely.
The guide references the monumental 2021 Supreme Court case, Google v. Oracle. We have to dive into this because it proves how weak copyright is for modern tech.
It's a watershed case. To understand it, we have to look at what an API is, an application programming interface. In simple terms, an API is a set of rules and protocols that allows different software programs to communicate with each other. It's like a menu in a restaurant.
A menu, I like that.
The menu provides a list of dishes you can order, along with the description. When you specify what you want, the kitchen, the underlying system, does the work and provides the dish.
Right, so you don't need to know how the chef cooks the meal. You just need to know how to order it from the menu.
Exactly. So Oracle owned Java, which is a massively popular programming language. And Java had this incredibly extensive API library.
It was basically a massive dictionary of pre-written commands that developers had spent years learning.
Right. If you wanted a program to figure out which of two numbers is bigger, you didn't write the math yourself.
You just typed a specific Java API command, and the Java system did it for you.
And then Google comes along. Google is building Android, a brand new operating system for smartphones.
And they want developers to build apps for Android.
But developers are lazy, or rather efficient. They already know the Java menu. They don't want to learn a whole new set of commands just for Android.
So Google essentially copies the menu.
They do. They write their own completely original code for the kitchen, the backend that actually does the work, but they copy the exact names, organization, and structure of the Java API commands.
They copy the expression of the menu so the developers feel right at home.
Oracle finds out, sees Google making billions on Android, and sues for copyright infringement, demanding an astronomical sum of money.
And this went all the way to the Supreme Court. Oracle argued, look, we wrote these specific lines of code defining the APIs. It's text, it's creative. Google copied it verbatim. That's copyright infringement.
But the Supreme Court looked at it and basically said, wait a minute, this isn't like a Harry Potter novel. This is a functional system.
Right.
The court ruled in Google's favor, determining that copying the API was fair use. The reasoning was deeply tied to the fact that these APIs were necessary to achieve a functional result interoperability.
The court recognized that giving Oracle a copyright monopoly over the basic building blocks of software communication would stifle innovation.
The declaring code was inseparable from the idea of the function itself.
So, if I've written an incredibly efficient, groundbreaking algorithm, let's say it compresses video files to half their size without losing quality copyright, might not even protect the underlying brilliance of how that math works.
It definitely doesn't. It only protects the specific way you typed the code on your screen.
So if a competitor looks at my software, figures out the mathematical idea behind my compression, and writes different code that achieves the exact same functional result, my copyright is entirely useless.
They took the valuable part, the idea, the method, and left the expression.
Which naturally leads every ambitious inventor and developer to the exact same thought process. Okay, if copyright won't protect how my software or my machine works, if it only protects the window dressing, then I need the heavy artillery.
I need a patent.
Right. The ultimate prize.
Yeah.
The gold standard of intellectual property. Let's look at utility patents first, because this is what people usually mean when they say patent.
Yes.
A utility patent protects how something works, right? Its function, its mechanical process, its internal structure, or its chemical composition.
A utility patent provides a very powerful negative right. It stops others from making, using, offering for sale, or selling your functional invention in the United States, or importing it.
It is a government-granted monopoly on a functional concept.
But the United States Patent and Trademark Office, the USPTO, does not hand these out lightly. They demand a very heavy toll.
And that toll isn't just financial, though it's incredibly expensive. It's an information toll.
Yes. To get a utility patent, you have to provide a written description of the invention that is so thorough, so clear, and so exact that any person having ordinary skill in that specific technical field could read your application and build the invention themselves.
Without undue experimentation, right?
Exactly. This is called the enablement requirement.
And beyond just describing it, you have to write formal claims. I was reading through the section on patent drafting, and the language used around claims is fascinating. The claims define the exact metes and bounds of the invention.
That is exactly how patent attorneys conceptualize it. Think of physical real estate.
Okay.
If you buy a farm, your deed describes the property lines, starting at the oak tree, going 500 feet north to the creek, then 300 feet east. That tells the world exactly what is yours and what belongs to your neighbor.
So in a patent, the claims are the linguistic property lines of your intellectual real estate.
You are drawing a linguistic fence around your concept. If a competitor's product falls inside the fence you described, they infringe. If they stay outside the fence, they don't.
But here is the massive, glaring problem with this entire system. Filing a utility patent is like publishing the exact high-resolution blueprints to your bank vault in the Sunday edition of the New York Times.
I love that analogy. It is so true.
You have to literally teach the world, step by step, exactly how your groundbreaking invention works.
We do.
And I can already hear you, the listener, pushing back on this. You're thinking, hold on, I'm smart. Why do I care if my competitors have the blueprints if they are legally forbidden from building the vault?
Right. Let them look at the blueprints all day long. The government gave me a 20-year monopoly.
That is the crucial question. And it reveals a fundamental misunderstanding of how corporate competition actually works.
The answer is found in the inherent limitations of the patents themselves and how engineers read them. Let's look at design patents for a moment to illustrate this vulnerability from a different angle.
Let's do it. So a utility patent protects function. A design patent protects the unique ornamental appearance of a functional item, its shape, its configuration, or the surface ornamentation applied to it.
Think of the specific curve of a smartphone screen, or the distinctive shape of a high-end perfume bottle, or the stylized grille of a sports car.
The design patent protects how it looks, not how it works.
And the disclosure requirements for a design patent are incredibly rigorous, just in a visual way rather than a linguistic way.
The reference material gets into the weeds on this. Under 37 CFR section 1.152, you can't just send in a hazy photograph of your product.
No, you absolutely cannot.
You must provide architectural level drawings that completely and unambiguously disclose the ornamental appearance. For a solid 3D object, you generally need 6 specific orthogonal views: front, rear, left side, right side, top, and bottom.
The government's rules on this are incredibly pedantic. You only omit a view like the bottom of a heavy machine if it's completely flat and featureless.
And you have to explicitly state in the application that the unshown portion forms no part of the claimed design.
Right. In a design patent, the drawings are the entire disclosure. There are no functional claims to read. The visual lines dictate the boundary of your monopoly.
So if I have a design patent on a gorgeous ergonomic new water bottle, I've just published the exact TAD-level drawings of it for anyone in the world to download.
You have, and here's why your bank vault analogy is so apt. A design patent on a bottle shape does not stop competitors from making a highly functional water bottle in a slightly different shape.
It doesn't protect the insulation technology or the leak-proof cap mechanism. It only protects the aesthetic wrapper.
And the reverse is true for utility patents. The guide clearly states a utility patent does not stop someone from copying the ornamental look, only the function.
Precisely. So let's go back to the utility patent and the listener's question. Why do I care if they have the blueprints?
When you file a utility patent, you create a massive, highly indexed, easily searchable database of your exact methodologies. You don't just tell them what the vault does, you tell them how the tumblers align.
Wow.
What happens in the real world is that a competitor downloads your patent. They give it to a team of their best engineers and patent attorneys. Their directive is not to copy your invention. Their directive is to design around it.
I love this concept of designing around. It's basically legal hacking.
It is.
Let's make this concrete.
Yeah.
Let's say I invent a revolutionary new gear system for an electric bicycle.
Yeah.
It uses a 5-gear planetary hub that shifts seamlessly under heavy torque. I spend $50,000 and 3 years getting a utility patent. My claims explicitly describe this 5-gear planetary assembly.
Your competitor reads that claim. They study the physics of your 5-gear system, which you so helpfully explained in the patent specification.
Because I had to for enablement.
Right. They realize the core principle is brilliant. But then their engineers ask, could we achieve 95% of this performance using a 4-gear sequential assembly?
Oh, man.
They test it based on your foundational research. It works. They build a 4-gear hub. Because your patent claims specifically required a 5-gear assembly to define its metes and bounds, their 4-gear assembly falls completely outside your linguistic fence.
They're not infringing.
Not at all. But they used your published knowledge to build a competing product in a fraction of the time it took you to invent it. You handed them the instruction manual, and they used it to beat you.
That is the chilling reality of the patent system. You are literally paying the government and paying lawyers to publish a how-to guide for your most well-funded rivals.
You are subsidizing their R&D department.
Which brings us to the next massive, unavoidable problem. Let's play devil's advocate. Let's assume you get the patent and your claims are incredibly broad and strong.
Okay.
You've built a linguistic fence so wide that nobody can design around it without infringing. You're protected, right? You have a monopoly forever.
Not even close. Now we hit the expiration date problem. Intellectual property, when it is registered with the government, is fundamentally a temporary lease. It has a ticking clock.
Let's run through these timelines because when you compare them to the lifespan of a successful company, they are stark.
Very stark.
If you get a design patent and you filed it on or after May 13, 2015, which the guide notes is when the U.S. aligned with the Hague Agreement concerning the International Registration of Industrial Designs, you get exactly 15 years of protection from the date the patent is granted.
Just 15 years. If you filed before that date, it was only 14 years.
And we have to ask, what happens on day 1 of year 16?
Your unique defining product design, the visual identity you spent a decade and a half building market share around, enters the public domain. It is stripped of protection.
Anyone, anywhere, can copy the physical shape of your product perfectly, legally, and sell it at half the price because they don't have to recoup your initial design costs.
What about utility patents? The big ones protecting the core functionality of our tech.
Utility patents are granted for 20 years from the earliest effective filing date of the application.
Not the grant date, the filing date.
Right. And since it often takes 3 to 5 years just to get the patent approved by the USPTO, your actual enforceable monopoly time is usually closer to 15 or 17 years.
And copyrights. We established they are weak for software function, but how long do they last for the expression?
Copyrights have the longest tail. For an individual author writing a book or a piece of code on their own, it's the life of the author plus 70 years.
For joint authors, it's measured from the last surviving author's death plus 70 years.
For a work, fire, or corporate authorship, which is what almost all company-owned software would be classified as, it's 95 years from the date of publication or 120 years from the date of creation, whichever expires first.
Okay, so copyrights last a genuinely long time, even if the protection is thin. But utility patents, the ones protecting the actual mechanical or algorithmic lifeblood of your technology, 20 years from filing.
But wait, I want to pivot for a second and look at the logistics of this. So I do the work. I show the world how my invention works in the application. The patent examiner fights with me for 3 years, but finally says, good job. Your claims are novel. Here is your 20-year monopoly.
Right.
Is the government taking care of the rest? Do I just frame the certificate, hang it in the lobby, and sit back and relax for 2 decades?
Far from it. This is where the crushing burden of maintenance fees comes in. The government doesn't just grant you a utility patent and let you be. You have to actively, continuously pay to keep it alive.
It is quite literally a subscription service for your own invention.
That's exactly what it is.
The Stars and Sand Guide details this schedule, and it's a trap for the unwary. You must pay escalating maintenance fees to the USPTO at exactly 3.5 years, 7.5 years, and 11.5 years after the grant date.
And if you miss one of those deadlines, the consequences are draconian.
What happens?
If your startup hits a cash flow problem and you decide to delay the payment, or if your law firm merges and loses track of the docket, or an administrative assistant simply misses an email calendar alert, your patent dies instantly. It expires prematurely.
Oh, wow.
Your protection vanishes overnight, and your fully published, deeply explained invention is immediately thrust into the public domain. It is now free for your competitors to use, and you have zero recourse.
There are some very limited grace periods with heavy surcharges, but if you miss those, it's game over.
Exactly.
And that's just the maintenance on the back end. The guide also mentions the total estimated costs through to grant, which is a polite way of saying how much you will bleed trying to get the patent in the first place.
The initial filing fee is just the tip of the iceberg. You are paying specialized patent attorneys who bill at hundreds of dollars an hour to write the claims and then to respond to USPTO office actions.
An office action is essentially the patent examiner rejecting your claims and citing older patents called prior art to say your idea isn't new.
Right. Your attorney then has to write a lengthy, complex legal brief arguing why the examiner is wrong or amend the claims to be narrower. This back and forth can happen 3, 4, or 5 times over several years.
You are constantly bleeding money to the government and to lawyers just to maintain a temporary monopoly that you had to publicly disclose your deepest secrets to get in the first place.
It feels like an incredibly raw deal.
Which brings us finally to the profound, elegant contrast of the trade secret. A trade secret, legally speaking, has absolutely no expiration date.
Let that sink in for a moment. No expiration date.
None, zero. As long as the information remains a secret and continues to hold economic value, it is yours forever.
Consider the most famous trade secret in history, the formula for Coca-Cola.
Classic example.
It was invented in the late 1800s. If John Pemberton had patented that syrup recipe, the patent would have expired roughly around the time of the Wright brothers' first flight.
That really puts it in perspective.
For the last century, anyone could have legally manufactured and sold the exact chemical compound of Coca-Cola under a different brand name. But because they kept it a closely guarded trade secret, they still hold a monopoly on that specific flavor profile over 130 years later.
There is no ticking 20-year clock.
None. Furthermore, there are no USPTO maintenance fees for a trade secret. There are no 3.5, 7.5, or 11.5-year deadlines to miss.
There are no patent examiners rejecting your claims, and no attorneys billing you to argue with the government.
So from a pure cost-benefit analysis, think about where your capital is going. Instead of taking tens of thousands of dollars and handing it to government bureaucracies and specialized lawyers to argue over the linguistic nuances of your public claims,
you take that exact same budget and invest it internally.
I love this concept. You invest that capital into your own organizational armor. You buy better, more secure servers. You implement tighter military-grade encryption. You hire top-tier cybersecurity personnel.
And what's fascinating here is the secondary benefit of that investment. Investing in trade secret protection benefits your entire company's infrastructure.
Exactly. A utility patent only protects that one specific claim, that one specific gear assembly or line of math. It does nothing to protect your customer lists, your marketing strategy, or your unreleased products.
But a secure server room, a robust culture of confidentiality, that protects everything your company does. It elevates the operational integrity of the entire business.
Okay, I'm completely sold. Trade secrets sound like the ultimate infinite weapon, but let's get practical.
Let's do it.
I can't just stand up in my office, Michael Scott style, yell, "I declare trade secret," and have it be a legally binding shield, can I?
No, definitely not.
If this is the superior permanent option, we need to know exactly how a business legally establishes one without the government sending them a certificate.
You're absolutely right. You cannot just slap a confidential sticker on a file cabinet and assume you are protected. The law requires you to earn the protection.
Earn it how?
Under U.S. law, specifically the Defend Trade Secrets Act of 2016, or DTSA, which is codified at 18 U.S.C., Section 1836, and the Uniform Trade Secrets Act, adopted by almost all individual states, there is a very strict two-prong legal standard that you must meet.
Let's break down these 2 prongs, because this is the bedrock of the whole strategy. Prong number 1. The information must have independent economic value from not being generally known or readily ascertainable by others who could obtain economic value from its disclosure or use.
Put simply, it is valuable specifically because it is a secret.
Right.
If your competitor knew it, they would make money off it, or it would save them significant time and research costs. It doesn't have to be a multi-billion-dollar algorithm. It could be a list of your most profitable clients, a specific manufacturing temperature that reduces waste by 5%.
Or even negative know-how, knowing what doesn't work after spending a year trying it, which saves a competitor from making the same mistake.
That makes sense. But here is the crucial insight from the guide, and this is a massive trap for entrepreneurs. The guide warns, economic value alone is not enough.
This is where so many brilliant tech companies and manufacturers fail catastrophically in court. Judges have consistently denied trade secret protection to highly valuable information-genuine, company-making innovations that clearly meet the first prong because the company completely failed the second prong of the legal standard.
And prong number 2 is the heavy lift. It states, the information must be subject to reasonable measures to keep its secret taken by the person seeking protection.
The guide says courts look for documented, consistent, and enforced security practices.
Precisely. The burden is entirely on you, the owner. If you invent a multi-million-dollar chemical process, but you leave the unencrypted formula sitting on a shared drive that any intern can access.
Or you leave the printed documents sitting on a desk in an unlocked office where the late-night cleaning crew could read them.
Right. The court will look at you and say, it wasn't a trade secret because you didn't treat it like one. You didn't take reasonable measures.
Here's where it gets really interesting. I want to build a real-world scenario to show what reasonable measures actually look like in practice.
I'm sorry.
Let's say you, the listener, are a founder managing a startup with a proprietary AI-driven logistics platform. It's the core of your valuation. How do you actually build this legal fortress? Because the STARS and SAN protection checklist is incredibly specific.
It's not just a vague mandate to not tell people. It's divided into structural pillars: physical and digital security, documentation, and legal agreements. Let's start with the physical and digital.
Let's build the fortress. On the physical side, courts want to see compartmentalization. If you have on-premise servers hosting the algorithm, they must be in locked rooms.
They want to see badge-controlled access. Only the engineers who specifically need to work on the AI core should have badge access to that room. The marketing team shouldn't be able to wander in.
If your server is sitting in a closet that everyone uses to store extra printer paper, you are failing the test of reasonable measures.
And digitally.
Uh-huh.
We are living in a remote-first world. It's not enough to just have a password on your MacBook.
Not at all. The checklist mandates enterprise-level security protocols. We're talking forced encryption on all company hard drives, mandated VPN requirements for any remote work connecting to company servers, complex rotating passwords, and mandatory multi-factor authentication for all internal systems.
But the real linchpin, according to my notes from the guide, seems to be access logs.
Access logs are critical. You need to maintain a digital, auditable trail showing exactly who can access, view, or modify each protected digital asset and exactly when they did it.
So if a competitor somehow steals your code and you sue them, the first thing the judge will ask is, who had access to this?
And if your answer is, all 50 of our employees, your case is dead. If you can produce a log showing that only 4 senior engineers had access, and one of them downloaded the entire repository to a USB drive at 3 a.m., 2 days before resigning to join the competitor.
Now you have a potent misappropriation case.
Exactly. You also need to audit that access continuously. When an engineer changes roles from the back-end algorithm team to the front-end user interface team, their access to the core algorithm must be revoked immediately. Principle of least privilege.
What about documentation? I can't just stand in court, point to my whole company and say, all our software is a trade secret, right? The court needs to know what they are protecting.
Right. Courts expect high specificity. You must proactively identify and catalog what information you are claiming as a trade secret.
The guide advises using visible, standardized, confidential, or proprietary trade secret labels on materials, documents, slide decks, and even embedded within the source code headers themselves. Every time an employee opens the file, they should be reminded of its legal status.
The guide also emphasizes the need to document creation dates, using strict version control, commit histories in your coding environment, and dated internal memos to establish a timeline.
You are essentially building an unbreakable chain of custody for your own ideas, proving exactly when you developed the secret compared to when the competitor suddenly invented it.
Which leads us to the human element, which is, without exception, the weakest link in any security fortress.
Oh, absolutely.
You can have the best encryption on Earth, but if an employee walks out the door with the knowledge in their head, you have a problem. This is where the legal agreements come in.
The NDA, the non-disclosure agreement.
You must have comprehensive NDAs with every single employee who has access to protected information. And the timing is absolutely critical. The guide specifies these should be signed on or before their first day of employment.
Not a week later when HR finally gets around to the onboarding paperwork. Not a month later when they get promoted. Day one.
Day one. Because if they access the secret on day 2 and sign the NDA on day 3, that secret was legally exposed for 24 hours. The chain is broken.
Wow, that's strict.
The same applies to contractor NDAs. If you bring in third-party developers, consultants, IT specialists, or even a marketing agency who might be exposed to proprietary back-end capabilities, they must be bound by strict legal obligations before they see a single line of code.
You must also conduct periodic employee training. It's not enough to have them sign a paper. Your team actually needs to be taught what constitutes confidential information and understand their ongoing legal duties to protect it.
And what happens when someone leaves? The exit procedure. You can't just throw them a goodbye party, eat some cake, and take their key card. The checklist requires a formalized, documented process.
The exit interview is a critical legal checkpoint. They must physically and digitally return all company property, laptops, phones, hard drives. You must formally, in writing, remind them of their continuing post-employment obligations not to disclose trade secrets.
And critically, you obtain a signed acknowledgement from them that they understand this obligation and have not retained any copies of confidential material.
You also have to consider non-compete clauses to prevent them from going straight to your biggest rival. Though the guide provides a very important geographic caveat here.
Right, like in California.
Yeah, California famously bans employee non-competes almost entirely, rendering them void as a matter of public policy. Other states, like New York or Texas, vary significantly in what they will enforce based on duration and scope. You really have to know your local jurisdiction.
That is true. Non-competes are geographically volatile. But an NDA regarding trade secrets is enforceable everywhere.
So let's summarize this entire section. Installing VPNs, enforcing two-factor authentication, making employees sign NDAs on day one, logging access. These aren't just IT best practices to keep hackers out. They are the literal, documented legal foundation of your intellectual property rights.
If you don't do these things, the right simply does not exist. You cannot enforce a trade secret in court if you didn't act like it was a secret in the office.
That is exactly the mindset every founder and CTO must adopt. The security is the legal right. The reasonable measures create the asset.
Okay, so I've done the work, I've built the fortress, my servers are locked, my code is labeled, my employees are trained and under contract. I have a bulletproof, infinitely lasting trade secret.
Congratulations.
But naturally, being the ambitious learner that I am, I look at the patent system and I want to ask the ultimate question. Can I have my cake and eat it too?
What do you mean?
Can I keep my revolutionary algorithm a fiercely guarded trade secret for, say, 5 or 10 years while I dominate the market, build a massive customer base, and then, once competition heats up, file for a utility patent later just to get that extra layer of absolute government protection? Can I transition from one to the other?
If we connect this to the bigger picture of IP strategy, this is where otherwise brilliant entrepreneurs make fatal, completely unrecoverable errors. The answer is a resounding, definitive no. Transitioning away from a trade secret to a formal patent or copyright registration is a catastrophic move.
Why? Why can't I stack my protections?
Because of the ironclad rule of permanent disclosure. Remember our earlier discussion. Filing a patent application inevitably results in the publication of that application by the government, usually 18 months after you file it, whether the patent is ultimately granted or not.
And we discussed the copyright deposit requirement at the Library of Congress?
Exactly. The moment that information becomes publicly known, the trade secret is permanently extinguished. It evaporates.
The guide has a whole section on this framed in a severe warning box. It reads, "Loss of trade secret status is permanent."
It emphasizes that unlike a patent, which has a defined term, once a secret is out, it's out. Whether it's through your voluntary failure to protect it by filing a patent, a malicious employee leak, or independent discovery by a competitor, there is no grace period. There is no reinstatement.
Once the genie is out of the bottle, no court in the land can force it back in. If you try to patent a trade secret, you are voluntarily legally publishing the secret to the globe. The trade secret dies the day the patent application publishes.
And remember the trap. That patent is only going to last 20 years at most. You'll pay massive fees to maintain it, and the examiner might ultimately reject your claims anyway, leaving you with no patent and no trade secret.
So you trade eternal, absolute, free control for a temporary, limited, and wildly expensive government lease that you might not even win. That sounds like a terrible deal.
It is a terrible deal.
Mm-hmm.
But the timing trap gets even scarier. Let's talk about the one-year bar danger under 35 U.S.C. Section 102b1. This is genuinely terrifying for anyone who wants to wait and see before patenting.
It is arguably the most rigid, unforgiving deadline in American patent law. The law dictates that any public disclosure of your invention starts a strict, unstoppable 12-month clock.
And what constitutes a public disclosure in the eyes of the USPTO? The pre-consultation checklist spells it out clearly. It's not just publishing a white paper. It includes a sale of the product containing the invention, an offer for sale even if nobody buys it, a demo at a trade show, or any public use.
Let's say I invent a new type of drone motor. I don't patent it. I keep it a trade secret. I put the motor in my drones and start selling them on my website. That is a commercial sale.
The moment that first sale occurs, the one-year clock starts ticking. If you sell it as a trade secret, you have exactly 365 days to decide if you want to file a U.S. patent application instead.
If you miss that window by a single day, If you try to file on day 366, your right to a U.S. patent is permanently, irrevocably lost. The invention belongs to the public domain from a patent perspective. You are statutorily barred.
So going back to my cake and eat it too scenario, if I've been successfully selling my software or my physical product as a trade secret for 3 years, and then a competitor starts getting close, and I suddenly panic and decide I want a patent, I can't.
The 1-year bar passed 2 years ago. The government will reject the application immediately based on your own past sales.
You are entirely barred. You committed to the trade secret path 3 years ago, whether you realized it or not. And it's vital to note that 1-year grace period is just a peculiarity of United States law. The international nightmare is significantly worse.
Yeah, the international note in the guide states that most countries outside the U.S., including massive markets like Europe and China, have absolutely zero grace period. They operate on an absolute novelty standard. Any public disclosure anywhere in the world before the filing date instantly destroys your ability to get a patent in those countries.
If you show your tech at a conference in Vegas on Tuesday without having attendees sign an NDA, and then you try to file a patent in Germany on Wednesday, you're out of luck. The European Patent Office will look at your Tuesday presentation and say your invention is no longer novel.
This is why IP strategy cannot be an afterthought. You must choose your lane early, understand the consequences, and stick to it. If you choose trade secret, you are committing to indefinite internal security.
Let me push back on this strategy, though, because I see a glaring loophole. What if a competitor figures out my secret without breaking into my servers?
How so?
Let's say I sell a physical product, like that drone motor I mentioned. It's incredibly efficient, and it's doing great on the market. A well-funded competitor buys my drone off Amazon. They take it into their engineering lab, completely dismantle it, analyze the circuitry, take apart the proprietary magnetic casing, and reverse engineer exactly how my secret mechanism works.
Okay.
Can I sue them for misappropriating my trade secret? Shouldn't I have patented the motor to stop them from doing exactly that?
This brings us to perhaps the most misunderstood aspect of trade secret law, and it's a critical distinction for any business owner. Under the DTSA, independent development and reverse engineering are not misappropriation. They are completely 100% legal.
Wait, really? It is perfectly legal for a billion-dollar company to buy my life's work, rip it apart with a screwdriver, and copy the secret mechanism they find inside?
Yes, provided they obtained the product legally on the open market, and there was no contract like a terms of service agreement preventing them from doing so. Trade secret protection only covers acquisition through improper means.
And improper means is defined as what, legally?
It includes corporate espionage, hacking your network, wiretapping, or inducing a breach of duty like bribing one of your engineers to break their NDA and hand over a thumb drive. It also includes physical theft. If they break into your warehouse and steal the prototype, that is misappropriation.
But if they buy it at Best Buy, take it to their lab, and take a screwdriver and a microscope to it?
That is fair game. The law encourages that kind of competition to drive innovation forward.
So this is the dividing line. If I know my product's innovation can be easily reverse engineered just by looking at it or dismantling it, that is when I should probably endure the pain of getting a patent.
Yes. If the core innovation is self-evident upon inspection, a new ergonomic shape for a hand tool, a mechanical hinge mechanism that is clearly visible, or a simple mechanical device where the function is obvious once disassembled, you cannot realistically maintain it as a trade secret once you release it into the stream of commerce. Reverse engineering is inevitable. In those specific hardware-centric cases, patents are a necessary evil.
But, and this is a vital strategic conclusion for the modern tech landscape, if your innovation is buried in millions of lines of hidden back-end code, if it's a complex AI training algorithm that runs entirely on your private servers, if it's a manufacturing process that occurs entirely behind the closed doors of your factory, or a chemical formula where analyzing the final product doesn't easily reveal the proportions of the ingredients.
Maintain the secret.
Because if you try to patent your back-end, non-visible trade secret, just to stop a competitor from potentially, maybe someday legally reverse engineering it, you are forced to disclose it publicly in the patent application.
Yeah.
You destroy the secret forever, and you literally hand them the perfect step-by-step blueprints for when your patent eventually expires.
You guarantee the very outcome you were trying to prevent. You do the reverse engineering for them.
That is wild. The strategic implications of that are profound. Okay, so this leads to a very practical, existential challenge for early-stage companies. Let's open up the entrepreneur's playbook.
Let's do it.
How does a startup founder actually operate in the real world? You have to safely launch a product, you have to raise funds from venture capitalists, and you have to build a massive public brand. How do you do all of that without violating your own trade secret, having someone steal your name, or accidentally triggering that one-year patent bar before you're ready?
This is where strategic use of different IP tools comes into play. You have to compartmentalize your business. You protect the identity of the product using a completely different legal framework than you use to protect the function of the product.
And we do that using trademarks, protecting the brand identity while keeping the function a secret. Let's look at the intent to use trademark strategy, because the Stars and Sand guide on this is an absolute game changer for early stage development.
A trademark is fundamentally different from a patent or a copyright. A trademark protects the distinctive visual identity of a product or service, a word, a logo, a slogan, as a brand identifier. It signals the source of the goods to consumers.
It ensures that when someone buys a phone with an Apple logo, they know it was made by Apple. It does not protect the function of the phone at all.
But launching a brand takes time. Developing the underlying trade secret software might take 3 years. You want to secure your killer brand name before you launch, while you are still secretly building the product in stealth mode.
Right, because the nightmare scenario is that I spend 2 years and millions of dollars writing code for a revolutionary platform I plan to call Project X, only to find out the day before launch that someone else in California trademarked Project X yesterday. I'd have to rebrand everything.
Exactly. This is where Section 1B of the Lanham Act comes in to save the day. The intent to use, or ITU, application.
Think of the ITU like placing your jacket on a seat at a crowded movie theater before the previews even start. You aren't sitting in the seat yet. You haven't launched your product in commerce, but you are legally reserving the space so no one else can take it while you go get popcorn.
The guide maps this ITU process out step by step, and it's a brilliant timeline.
Step 1. You file the ITU application. You submit the mark you want, either standard text characters or a stylized logo design. You provide a description of the goods and services using the correct NICE classification class. But crucially, you don't need to provide a specimen showing that you're actually using the mark in public commerce yet.
And the strategic power of this is that your filing date immediately becomes your nationwide priority date. You are planting a flag in the ground. If a third party starts using the exact same mark the day after you file your ITU, you will eventually defeat them in court, even if they launch their product and start selling before you finish developing yours.
That is incredible. You're holding your place in line while you work in the secret lab. Let's look at the hurdles, though. Step 2 is the USPTO examination, taking roughly 3 to 6 months. They check for distinctiveness and, primarily, likelihood of confusion with existing marks.
Likelihood of confusion is the most common reason for a trademark refusal. The USPTO wants to ensure consumers aren't tricked. However, confusion is judged within specific classes of goods. This is why Apple Records, the Beatles music label, and Apple computers could coexist for decades before digital music blurred the lines.
They were in completely different industries, so consumers wouldn't be confused. But you cannot reserve a name that is confusingly similar to one already registered for related goods or services.
The guide also warns against choosing bad names to begin with. The USPTO ranks distinctiveness in a very strict hierarchy.
At the top are fanciful marks. These are completely invented words with no dictionary meaning, like Kodak or Exxon. Those are the strongest possible trademarks because they only mean one thing.
Then you have arbitrary marks, a real word with a completely unrelated meaning to the product, like using APLE for computers.
Moving down the spectrum, you have suggestive marks, which imply a quality or characteristic of the product without directly describing it, requiring a leap of imagination. Think of Netflix X for movies on the internet, or Coppertone for suntan lotion. These are good, registrable marks.
But the massive trap for entrepreneurs is choosing merely descriptive marks.
Like trying to trademark fast for a delivery service, or cold for ice cream, or reliable for accounting software. The guide says these are inherently weak. The USPTO will usually refuse them outright unless you can prove 5+ years of acquired distinctiveness, meaning the public has come to associate that generic word specifically with your company through massive advertising.
And generic terms, like trying to trademark the word bicycle for a company that sells bicycles, are never, ever registrable.
So the lesson is, pick a strong, fanciful, or arbitrary name and file the ITU early.
Precisely. Once the USPTO approves your ITU application, it goes to step 3, publication in the official gazette. This is a 30-day window where any third party who thinks your mark infringes on theirs can file an opposition.
If you survive that 30-day period with no opposition, you reach step 4, the Notice of Allowance, or NOA.
And this NOA is essentially a conditional approval. It starts a 6-month clock for you to file a statement of use, which is the proof, like a photograph of the product or a screenshot of your e-commerce checkout page showing you've actually launched the product in public commerce.
But here is where it ties perfectly into the trade secret strategy. What if you are still developing the algorithm? What if the software is still 2 years away from being secure and ready for the public? You can't file a statement of use because you aren't selling it yet.
This is the best part. The guide outlines extension deadlines. You can request 6-month extensions for a nominal fee, and you can do this up to 5 times beyond the initial period. That gives you a maximum of 36 months from the notice of allowance.
So you have up to 3 years of protected runway. You can sit in your office, build your product securely behind closed doors, maintain absolute trade secrecy, raise venture capital, and prep your massive marketing campaigns, all while knowing with absolute certainty that your brand name is legally locked down nationwide.
And when you finally launch, you file Step 5, the statement of use with your specimen. Step 6, registration. And your legal rights date all the way back retroactively to that original ITU filing date years ago.
And unlike utility patents with their 20-year death sentence, as the guide notes, a maintained trademark can last indefinitely. As long as you keep using it in commerce and file your maintenance declarations between years 5 and 6, and every 10 years after that, you own that brand forever.
It is the perfect complementary tool to a trade secret strategy. You lock down the public-facing brand identity indefinitely with a trademark, while keeping the back-end functional mechanics secret indefinitely with DTSA compliance.
It's a beautiful dual shield approach. But I have to bring up the fundraising reality. To get the money to build the software for 3 years, I have to pitch to venture capitalists. I have to hire external security auditors. I have to talk to potential vendors and manufacturing partners.
Right, you can't build it in a total vacuum.
How do I do that without blowing the trade secret and accidentally triggering that 1-year patent bar by disclosing my invention?
It all comes back to documentation and legal agreements, returning to our anatomy of a trade secret. You absolutely must use customer and partner NDAs before sharing any sensitive processes, negotiations, pitch meetings, or due diligence.
You cannot just trust a handshake with a VC because they seem friendly over coffee.
Never. The law does not recognize friendly handshakes. It recognizes executed contracts. You also need comprehensive vendor agreements that strictly restrict how third parties can use or disclose any information you provide them. Your supply chain has to be as bound by confidentiality as your own internal employees. If your cloud hosting provider isn't legally bound to keep your data secret, your trade secret is void.
But let's say disaster strikes. Let's look at a very common scenario for founders. I'm in a pitch meeting with a top-tier venture capital firm. They refuse to sign an NDA, which, let's be honest, many VCs refuse to do because they look at thousands of similar companies a year and don't want to get sued if they fund a competitor later.
It happens all the time.
But I absolutely must disclose the conceptual mechanics of the invention to them in order to prove it works and get the $3 million seed round. If I explain the core architecture to a room of un-NDA'd investors, have I just destroyed my trade secret and started the 1-year bar clock?
You have certainly destroyed the trade secret aspect of whatever specific functional mechanics you explicitly disclosed in that room. Without an NDA, you failed to take reasonable measures to keep it secret.
Wow.
And yes, you have likely triggered a public disclosure event that starts the 1-year clock for filing a U.S. patent. But there is an emergency valve mentioned in the utility patent checklist for exactly this scenario.
The provisional patent application.
Yes, if you find yourself backed into a corner where you absolutely must disclose an invention conceptually to un-NDA'd parties to secure funding or partnership, a provisional patent application can stop the 1-year clock cheaply and quickly.
As the guide states, it establishes your priority filing date with the USPTO at a minimal cost. Crucially, a provisional application does not require the formal, highly complex, expensive claims that a full utility patent requires. A clear written description of the invention and some rough sketches are generally sufficient to secure the date.
So it's essentially a legal bookmark. It buys you exactly 1 year of breathing room. You file it for a few $100s on Monday, pitch to the VCs on Tuesday without an NDA, and you have 12 months to decide if you want to spend the big money to file a full, formal, non-provisional utility patent.
Correct. It preserves your rights while you test the waters. But we must guide the listener back to our core thesis today. You only use a provisional patent as an absolute last resort emergency valve. If you file a provisional and then follow through with a full non-provisional patent a year later, you are stepping right back onto the path of mandatory public disclosure.
You will eventually be forced to publish the blueprints, you will be hit with the maintenance fees, and you will be subject to the 20-year expiration date.
The primary goal, the most robust strategy for long-term wealth creation, should always be to rely on robust internal NDAs, strict server security, and a disciplined trade secret framework so you never have to pull that provisional patent lever in the first place.
Wow. Okay, we have covered a massive amount of ground today. We've gone from the theoretical foundations of intellectual property right down to the tactical realities of pitch meetings and server access logs. Let's do a final synthesis and bring this all together for you, the listener.
When you create something groundbreaking, the instinct to run to the government for a shiny formal certificate is incredibly strong. Patents and copyrights offer a feeling of security. And yes, to be fair, for certain things like published novels or easily reverse-engineered physical tools like a new wrench design, they are absolutely necessary.
But for the vast majority of modern technological innovations, back-end algorithms, internal manufacturing processes, data sorting structures, AI training models, those formal registrations are an alluring trap.
They demand the permanent, irrevocable sacrifice of your secrets to the public record. They saddle your growing business with tens of thousands of dollars in ongoing maintenance fees and legal bills. And eventually, inevitably, the clock runs out. They expire, leaving your life's work, the foundation of your company, sitting in the public domain for anyone in the world to copy and profit from.
Whereas trade secrets, when properly established and rigorously maintained, offer a different path. Fortified by digital padlocks, mandatory day one NDAs, strict compartmentalization, and rigorous access logs, trade secrets offer indefinite protection. It is a form of protection that you completely control, funded by internal investments that secure your entire company's operational integrity, rather than paying fees just to prop up a single patent claim.
And that leads us to our final provocative thought for today's deep dive. Something for you to mull over as you build your next project, based on everything we've unpacked from the realities of the Defend Trade Secrets Act.
If independent development and reverse engineering are completely legal under federal law, and if patenting your invention just hands your competitors the highly detailed instructional blueprints to design around your life's work, then the true defining battleground of modern business isn't happening in a federal patent courtroom.
It is happening in your company's hiring practices. It's happening in your digital encryption protocols. It is happening at the doors of your server room. Your most valuable asset isn't protected by a government stamp on a piece of paper. It is protected by the culture of security and discipline you build within your own walls.
So ask yourself right now, is your internal fortress truly secure enough to withstand the legal right of your competitors to try and tear your product apart?
Thank you so much for taking this deep dive with us today. Keep building, keep learning, and above all, keep your secrets safe. We'll see you next time.